Hello, my name's Joshua Bliel, and I'm an attorney with the Tickton Law Group. Wanted to take a few minutes to explain how the Tickton Law Group is different than a vast majority, if not nearly all, of the attorneys or firms that are doing foreclosure defense work. The biggest difference with our office and other offices is that we actually fight the foreclosure cases. And fight the case means different things to different people, and it's worth some explanation. For whatever reason, foreclosure cases have kind of taken on a nature of their own, where the defense attorneys and to even some extent some of the judiciary think that these cases are not cases that can be litigated. Nothing could be farther from the truth. We fight the cases. It's not our intent or our objective to delay the cases. And when I say litigate, it may sound strange, but we treat the foreclosure cases like any other kind of a lawsuit. We do our discovery. We do our request for production. We send the bank interrogatories. We're very often taking depositions of some of the bank's representatives or of witnesses that they present in the court. And what that does is that it allows us to raise, foster, and develop the defenses that our clients are entitled to and that our clients need. Also, what we do is we go to hearings. And when we go to hearings, we actually oppose the bank on a number of bases. Sometimes we'll find a common ground. Fine, we can resolve that. But the biggest hearing that I'm thinking of particularly is when the bank moves for summary judgment. And essentially, the bank is going to say, there's no genuine issue of material fact here, and we are entitled as the bank to a judgment as a matter of law. In layman terms, it says, Judge, the case is so simple, you don't even have to waste your time with anything else, just give us a judgment. Well, through our litigating the case, when it comes time for that summary judgment, we at the Tickton Law Group have a very high success rate at overcoming that summary judgment. And the reason is because we've done our discovery. We've done an analysis of those documents. We've taken depositions of their witnesses and understand and appreciate where those factual and legal weaknesses are, so that whenever that summary judgment comes up, we can actually oppose it. And once that summary judgment is opposed, the plaintiff has to look at the case a little bit differently. Now they've got to gear it for a potential trial. And through our process of actually litigating and fighting the case, that's an avenue that many of our cases are going to get to. And what I see with many of the defense firms or the attorneys that are defending the foreclosure cases on behalf of the borrowers is that they've got a delay mentality. And it doesn't take a savvy attorney to delay a case for 4 or 5 months. But once you've delayed a case for 4 or 5 months, and now you go to your summary judgment hearing, if you don't have something to oppose the bank with, you have no case. And that's where many times I see the defense attorneys at the summary judgment hearing consenting to sale dates. And they think they're doing their clients a justice by, extending the sale date for 60 or 90 days. I don't see that as any kind of a service for our clients, nor do the attorneys here at the Tickton Law Group. So once we make it over that summary judgment hearing, which we often do, now we're in a traditional kind of a case that gets to be litigated. Along those same lines, something or a phrase that often comes up in these foreclosure cases is that of loan modification. And a modification, by definition, is changing the original terms of the deal. The most common modification that I see is one where the bank agrees to take whatever is delinquent on the account and put it on the back end. And sometimes that means extending the term of the mortgage for another 10 years. And that's the modification. The borrowers or the public see modification as a reduction in principal to put what's owed more in line with the current value of the property, or reducing an interest rate that would now make the payments more affordable from going from an adjustable rate down to a fixed rate. Those are also goals that we try to achieve here at the Tickton Law Group, but those goals are much easier to achieve and much easier to foster a settlement if we've actually litigated the case. And through that litigation process, we expose the weaknesses of the bank and focus on the strengths of our case. So now when it comes time for a mediation or settlement discussions come up, it's not an extended loan modification session. Now we can actually sit down and we have a position to bargain from. So now it gives us the strength to try to bring a settlement to the case. Sometimes a settlement will be achieved, sometimes it won't. And if the settlement's not achieved, we're not necessarily unwilling to take these cases to trial. In fact, if it's not a decent settlement or an advantageous settlement for our client, we in a way have an obligation to take that to the next level. And that's also where litigating the case comes into the field big, because if we haven't done our depositions, if we haven't fostered our affirmative defenses, if we haven't built a case for our client, we're also going to lose at a trial. So that's the biggest difference that we here at the Tickton Law Group bring to the foreclosure cases, is that we have the mindset of winning. We're not afraid to fight the bank. We're not afraid to litigate the cases. And we also do a service by our clients. And we have a number of clients with a number of different issues. Each client has a unique set of circumstances that plays into their case, one of which would be the amount of the mortgage. We have mortgages that range from anywhere from $100,000 up to multi-million dollars. And each case is taken on its individual merits and looked at and evaluated. And here at the Tickton Law Group, all of our clients get the same level of consistent service. Whether you have a mortgage that's $100,000 or a $2 million mortgage, this is that person's house. This is their nest egg. This is where they've lived. This is where their family is. They're emotionally attached to these things, or their homes. And that's what we do here at the Tickton Law Group. We really fight the cases. We take into account those individual circumstances that each borrower has. And we can also play up the similarities that each mortgage foreclosure case has. So litigating the case is what we do. And that's a big difference from what most of the firms are doing as far as either delaying the case in the courts or pushing for a modification, which could be requalifying the borrower for the loan that was done 3 years ago the right way, actually looking at their real income, looking at their true income to debt ratio, looking at their credit scores, or modifying the loan, putting what's owed in the back end. That's not what we're trying to do for our clients. What we're doing is we're fighting the case. We're taking the banks on their turf in the courts and actually achieving results that are advantageous for our clients.